The meeting for the Planning Commission for Monday, August 26, 2024 is hereby called to order at 6:31 p.m. Christina, can you call roll, please?
Mitchell,
Here.
Moreno,
Here.
Najak,
Here.
Rigby,
Here.
known as excused, Sly,
Here.
Twing,
Here.
Councilman Boop is also joining us.
Yeah.
Councilman Abub, do we have a city council update?
Yes, ma'am. Thank you. Thank you, Chair. Thank you, everybody. I miss you. I was in a long trip, so I'm glad I'm here. Yeah, I think you are working on the SB 1537 today. We, work on it on July 30th. And, I think what we say, we were applying for an exemption. You'll go over those things. The city will, and yes, we know there are some complicated things like the Westlake Grove where there is no variances and stuff like that. We have the staff who will say more about that. So that's one of my updates. And talking about those, there's also something that's going on about Hacienda. Misinformation coming from some media saying, Hacienda is all like kind of handing out money to everybody. That's not true. It's just, the Hacienda is working on a project that, is supporting people for down payment, and it's for people who historically marginalized groups, like in rural area, people who are, considered poor, or in some low-income minorities. That's, the program is for those. They made a mistake on a flyer that said, I think, for non-Americans, like for non-citizens only, but it was not true. I think they fixed that thing, and, people use sometimes anything on their platform to advance their agenda, but that's not true. If you hear about that, that's it's time, to say that. I know Hacienda, they have some ethics and have they're professionals on what they're doing. And so that's something we need to tell people. And we also had a hearing on, program for enhanced recycling. Readwell was, something that we know in our city, and most people came to testify for them to stay in the city. But what the city decided that we are going to create, some licensing programs for, it was mainly for Readwell, but it's open to everybody to apply for that. And I think staff will work on that, and Republic Services also that's serving us can have that program of recycling, there's some objects that are very difficult to recycle, and that's what Readwell was doing, like batteries. Every time you say, where am I going to put this? So they serve well Lake Oswego, and so the city is supporting agencies like that. And also good news, we have our judge retired, and we sworn in a new judge, Sierra Brown, who is, known here. She came sometime and worked with the city for some years. So she's now the new municipal court judge, and her name is Sierra Brown. And we also adopted the Public Art Master Plan and Guidelines. It is very important. It's been a long time in haven't done, so we did it. And, that was an important thing that we did. So I think that's all I have. I don't know if I should stay for this because I already,
You already heard it.
yeah,
You're welcome to.
to stay or to go. Yeah, yeah. Thank you. I miss you all, and I'll see you another time.
It's good to have you back. Thank you for the report.
Thank you. If you have any question, I'm here before I leave. Don't see you on the pitch. Thank you.
So next up, we have approval of minutes for July 22nd, 2024. Do we have a motion to approve the minutes?
I'd like to move to approve the minutes of July 22nd.
We have a motion. Can we have a second?
Second.
Second. All those in favor? Aye.
Aye.
Anyone opposed? Motion passes. And Cristina, do we have anyone signed up for public comment? Not today, thank you. The Commission for Citizen Involvement, general updates. I usually receive like a postcard in the mail or email. I didn't see any. There's no communication. Okay, moving right along, we have a work session for the variance audit as Senate Bill 1537, PP 24-0004. The Commission will receive an update on the implementation of Senate Bill SB 1537 in Lake Oswego. Staff Coordinator Jessica
Numanolu.
Numanoglu, Community Development Director.
Thank you, Chair Moreno, and good evening to all the commissioners. This is an update on Senate Bill 1537, and you all, except for the new commissioner, received previously some updates on the state legislative session a short session that ended earlier this spring. The first update that you received was from Madison Thiesing in the city manager's office, and she gave you a general update of the legislative session, including Senate Bill 1537, although she gave just a broad overview at that time, back in April. And she mentioned at that time that we may need to do some code amendments in order to comply with SB 1537. So one of the things I will be talking to you about today is a little bit more in depth is what, if anything, we need to do to comply with SB 1537. We also received an update from DLCD, the Department of Land Conservation and Development staff, in May, who provided an update on the Housing Accountability and Production Office, which is a component of SB 1537. And they also talked about, to the Commission, about the Oregon Housing Needs Analysis rulemaking that is currently underway, and that is actually from the 2023 legislative session. But in the work session today, I'm really just going to focus on Senate Bill 1537 and just talking to you in general about what, if anything, the city needs to do to comply now that we've received some guidance from DLCD, which we didn't have until about 2 months ago. So let's get started. So for the presentation today, I will be providing a brief overview of SB 1537, and I'm just going to briefly talk about all the components because there's a number of components that were included in that bill. I'm going to focus mainly on the Housing Accountability and Production Office, which I'll abbreviate as HAPO for ease of speaking, and then also the housing land use adjustments, and then we'll have some opportunity for questions. I am not asking the Commission for any sort of action or direction today. It's really just an update because this bill has a lot of components, and there's some particularly the housing land use adjustments is one that we've been concerned about. So I want to make sure you know what the latest is with that. And I do want to apologize. I've got a bit of a cough, which is irritated. I've got some sort of air above me, the air conditioning unit. So I apologize if I have a little bit of a coughing fit. I am not sick. I had COVID about 2 weeks ago, but I am better now. But I apologize if I do have a little bit of a coughing spell. Okay, so let's start with the overview of the bill. So as you might recall, SB 1537 was Governor Kotek's bill to specifically address the severe housing shortage in Oregon. As you know, she's declared a housing emergency. This was kind of her signature bill to address a number of issues related to housing. And it's supposed to increase the production of housing units through a variety of tools, and these include funding, infrastructure, land supply, as well as regulatory barriers to housing. That's all the components that it's supposed to address. The bill, as I mentioned, has many components. The Planning Commission report focuses on these bolded components that I have listed here. But I am really going to focus, as I said in my presentation, on the two things, HAPO and the mandatory land use adjustments. But to generally summarize, the bill establishes HAPO, and this is specifically to support and enforce housing laws. I'll be talking about that more in a minute. Another component is it lets builders opt into regulations that are changed during the review of their land use application for housing. And we also call this the goalpost rule, and this is something that I talked about in more detail in the Planning Commission report. There's another component that changed how attorney's fees would be awarded in the cases of appeals. So previously, attorney's fees only had to be paid by a local government to an applicant for specifically an affordable housing development if it was denied by the local government and that decision was later reversed by the Land Use Board of Appeals. They've expanded that now so that any petitioner that files an appeal, if that of a housing land use application, if that housing land use application is ultimately affirmed and approved by LUBA, that petitioner is on the hook for paying both the attorney and the the attorney's fees of both the applicant and the local government. So it's sort of a disincentive for people to file frivolous appeals, essentially. The bill also establishes a housing infrastructure support fund as well as a housing project revolving loan program, which we're going to keep our eye on. We'll know more about that later next year when that program has to be, that revolving loan program has to be effective. It also has a component that requires applications for replats, lot line adjustments, and extension, alteration, or expansion of nonconforming use to be classified as a limited land use decision. A limited land use decision is essentially what we call a minor development in our process. It also requires local governments to approve up to 10 mandatory adjustments to land use regulations if housing project meets certain state eligibility requirements. That's what I'm going to talk about here in a bit in more detail. And then finally, it provides an option for a city to add a site within the metro urban growth boundary if the site meets certain eligibility requirements and the housing development meets specific density and affordability criteria. So as you can see, there was a lot of components to this bill. But I discussed in the staff report, the city complies with the updated goalpost rule right now, outright. So there's nothing more we need to do on that. We also comply with the reclassification of certain land use application as limited land use decisions, so there's no further action that we need to take on that. So really, for the rest of the presentation, I'm just going to focus on HAPO and the land use adjustments. So what is HAPO? As a refresher, this is, well, first of all, it doesn't exist right now. It is required to be operative no later than July 1st, 2025. So it will be, when it is created, a joint office between the Department of Land Conservation Division as well as the State Building Codes Division. And its purpose is to support local housing production. And it does that through three main functions and duties. The first is that they're responsible for implementation of state housing laws. So they will be authorized to investigate complaints about local government compliance with state housing laws, which is something that we have some concerns about, because if we're going to now have to start responding to complaints from builders and developers that the city doesn't comply with housing laws or is somehow obstructing or housing production, that's a big concern for us. I mean, we have a lot of work going on. We have a lot of state mandates we're still trying to comply with. So that's been a big concern for us as well as other local governments as to how this is going to play out. And while the statute does lay out some of the, how it will proceed, we don't have all the procedures or how this is going to be implemented. So we'll just have to wait and see how this rolls out. They're also required to serve as a resource to comply with housing laws to both local governments as well as applicants. This would include things like providing technical assistance, financial assistance, guidance, as well as mediation services. They've been awarded $4 million to use as technical assistance funds, and this would to support local governments for any code work that they would need to do to comply with housing laws. So that's a good thing, that at least it's not a completely unfunded mandate, whereby if the city has to update their housing laws, there is funding available from HAPO in order to accomplish that. And then finally, in terms of implementation of state housing laws, they do have enforcement authority to pursue if voluntary remedies are not followed by the city to comply. We have been assured up and down many times from DLCD that their first course of action is to work with cities to gain voluntary compliance. So it's not like they're going to bring down the hammer from the very beginning. So that's good news, but ultimately they do have enforcement authority if it comes down to it. Another one of their functions is to provide state agency coordination. And this would look like identifying technical and financial resources to unlock opportunities for housing production, as well as coordinating state agency policies and programs that facilitate housing production. And then finally, their last function is to produce studies and research and guidance. So this could look like model codes that cities can use as best practices. It could be ready-built plans to help streamline approvals. This is something that we're keeping an eye on because one of our housing production strategies is pre-approved ADU plans. So if that's something the state is going to be developing, that may be a resource for us that we can use for compliance with our housing production strategy. They'll also do studies to identify barriers and opportunities to housing production as well. As I mentioned before, the operative date that they have to be up and running is July 1st, 2025. Once that date comes, they can start taking complaints at that point. And as far as complaints go, the only thing that we know at this point is that if someone wants to file a complaint about a specific development project, so let's say somebody is, I don't know, building a housing project, on the corner here, the only person or entity that can submit a complaint to HAPO is the applicant. So a neighborhood association can't file it unless they're the applicant, nor can anyone else in the city. If there is a general complaint, say that somebody believes that the city's code just doesn't comply with some sort of housing land use law, anyone in the city's jurisdiction can file a complaint, as well as the Department of Land Conservation or the Department of Consumer and Business Services. So there is an opportunity for broader complaints, but it's not about a specific project. It has to be a general issue with the city or city codes. There are some things that HAPO can't do, and one of those is they will not review Goal 10 requirements. So Goal 10 is the housing land use goal. And so for instance, right now, one of the things that we're doing to comply with Goal 10 is we've adopted our housing needs analysis, and we're in the process, as you know, of adopting our housing production strategy. And HAPO will not be responsible for reviewing those. So that will still be under the Land Conservation and Development Commission, or DLCD. HAPO will also not review complaints that are under the jurisdiction of the Land Use Board of Appeals. So for instance, if we have a housing land use application that's appealed to the City Council, that's further appealed to the Land Use Board of Appeals, HAPO will not get involved in those. They will also not get involved if a party files private litigation regarding a housing land use application. They will also not be involved in that situation. If it comes down to a local government not voluntarily complying, as I mentioned before, they do have legal authority to take action, and includes things such as initiating an enforcement order, seeking a court order against a local government, applying to circuit court for an order compelling compliance with any housing law, So it does have teeth, but again, we've been assured many times by DLCD that that is not going to be their first course of action. So hopefully that will be only as a last resort. So that is HAPO in a nutshell. That's what we know at this point. Before I move on to the housing land use adjustments, does anyone have a question about the Housing Accountability and Production Office? Okay. Seeing none, I will move on to housing land use adjustments. So this is another big component of the bill that not only the city had concerns about, but the League of Oregon Cities and other jurisdictions had a lot of concerns about this component of the bill. And we submitted a lot of comments as well as League of Oregon Cities, and I'm happy to say that many of the comments that we had were taken into consideration, and they did incorporate that into the bill, which I'll talk about, which we're very relieved about, but it is still, these land use adjustments are pretty broad and the criteria are not very stringent. So I think we still have concerns about it, but it is better than what the legislation started out as. The operative date for these state mandated housing land use adjustments is January 1st, 2025. And what it does is it requires local governments to approve up to 10 distinct adjustments for housing development if it meets certain eligibility requirements. Those adjustments are listed in the staff report. I included a pretty long table in there. I am not going to go through all of those, but it ranges from setbacks to height, minimum parking, landscaping requirements, those types of things. They cannot get adjustments to things like allowed uses in the zone. That is not permitted. They can't get adjustments to fire, life, and safety issues. They can't get adjustments to tree codes. That was a big one that cities were concerned about. They can't get adjustment to anything involving sensitive lands protection, stormwater requirements, federal or state laws, or other local laws that are not land use regulations. So it's really just limited to that table that I included in the staff report. In order to be eligible for the adjustments, there are a number of requirements that have to be met, which I've sort of generally summarized here. It has to be located on land that's zoned for residential or mixed use. There is a minimum density requirement. This was a big one for cities because before it was written, there was no guarantee that anyone even had to show that they were going to have an increase in the number of units or that they were going to be more affordable. It would have just allowed 10 adjustments carte blanche. And our concern here in Lake Oswego especially is we have people who are building very large single-family dwellings, and we don't need those to be bigger and more expensive. So that was our concern, was that without some sort of a density or affordability requirement, what are we really getting here? So they listened and they did establish this minimum density of 17 dwelling units per acre. And I'll talk, I have a slide on that as to how that translates in Lake Oswego next. Another eligibility requirement is that it has to be located inside the urban growth boundary. So this is not going to be applicable to unincorporated lots in Clackamas County. It's only applicable within our UGB. It has to result in net new housing units, but it can be of any kind. So technically, it could apply to single family if you can meet all the other eligibility requirements. But unlikely, as I'll talk about, to happen in Lake Oswego. And it has to meet one feasibility, affordability, accessibility criterion, or reduce the sale or rental price, or increase the number of units. So again, I'm sort of generally summarizing these things, but it's good that they have these additional criteria because that legislation didn't start out that way. So as far as the procedure, the city is allowed to apply this statute directly, so we don't have to make any code amendments if we are going to just go ahead with these state mandates and not apply for an exemption. We just apply it directly. And in fact, DLCD does not recommend adopting amendments to conform to the land use adjustment requirements because, as you can see, it does have a sunset date. So on January 22nd, 2032, this will go away. It will no longer be effective. So it's best if we don't have to change our code. So it's going to be effective for about 7 years. Sure. One of the issues that we have with the criteria is that the applicant really just has to state that it's going to meet one of these feasibility criterion or affordability or accessibility. There's really no burden of proof. It actually shifts the burden of proof to local government to produce findings as to why they don't meet the requirement. So that's one of the things that we submitted comments on that wasn't incorporated into the legislation. So we were very disappointed that that didn't happen. But they did throw us a bone and allow this exemption process whereby if the city has existing processes that allows all of these adjustments that are listed in the state in SB 1537, that we can apply for an exemption. So there is at least an out there for local governments to use their own processes if they can show that they have a process where someone can ask for those adjustments through a city process. But I'll talk about that here in just a minute. So getting to the density requirement, as I mentioned before, one of our biggest concerns was that this could be applicable to single-family dwellings. So they adopted this minimum density requirement. And essentially, it requires 17 dwelling units per acre, which boils down to 1 unit for every 2,562 square feet of lot area. So many of our zones have minimum lot areas, not all of them. But for instance, if you're in like a low density zone, like say an R15 zone, you are not eligible for these adjustments unless you propose a cottage cluster or greater density. So it's really not going to be applicable ever to a single family dwelling. The only exception is if there was like a non-conforming lot in a zone that was 2,500 square feet, then I suppose they might be eligible to get adjustments for a single-family dwelling. But if that's small of a lot, you're probably going to need variances anyway. So they would have ended up applying for variances because that's a very tiny lot in an R15 zone. So yeah, there is some possibility. And as you get into the higher density zones, so for instance, in the R6 zone, there's a 6,000 square foot minimum lot size. But again, they wouldn't be eligible for those adjustments unless they proposed a duplex or greater. So at least you're getting more units. As I mentioned, there is this process to apply for an exemption to the state-mandated housing land use adjustments. And in order to qualify, the city has to meet one of these two criteria here on the first 2 bullet points. So the first one is that they have to show that all listed development and design adjustments that are in the bill, again, it's in that table in the Planning Commission staff report, are eligible for an adjustment under one of city's current processes. We also have to show that within the previous 5 years, the city has approved at least 90% of all of the received adjustment requests. So that's one. The other option is that they have to show that the adjustment process is flexible and accommodates project needs as demonstrated by testimonials of housing developers who had utilized the adjustment process within the previous 5 years. I would not hang my hat on that second one. I don't know that we would get a lot of maybe we would, but I think we would more want to show compliance with the first one because I think that is something that is clear and objective that we can actually provide data on. So in that spirit, if we apply under that first exemption, I will note that the city has several processes for requesting variances or adjustments to its code standards. And we've looked at it. We've approved more than 90% of received variance requests in the last 5 years. So in fact, between 2018 and 2023, there were 96 variances for housing development applied for, 100% of which were approved. So the city would meet that criterion as long as we continue to have that 90% or better approval rate. What is unclear to us is whether or not a major variance process would qualify as meeting the criterion that all of the adjustments listed in the bill are eligible for an adjustment under the city's current process. Because what I can tell you is that we have this umbrella variance, which is a major variance, which is technically applicable to almost any standard in the code, and certainly every standard that's listed in the bill. But that particular type of variance is basically a hardshape-based variance, and it has limited applicability, mainly to physical circumstances of the site or existing structure. So for instance, if you look at the purpose of a major variance, it is to consider special circumstances or conditions that are beyond the applicant's control and where the application of code standards would result in undue and unique hardship, or that failure to grant a variance would result in code standards applicable to the property, essentially creating a taking of private property. So it's a high bar. And if we look at the number of major variances that have been applied for in that same 2018 to 2023 time period, only 8 of the 96 housing development variances that were applied for were major variances. All of them were approved, so 100% of them were approved, but you can see it's a really small component. So our concern is that if major variances are the only option for many of these adjustments, and they are apply, whether or not they're approvable, or because, excuse me, they're approvable in limited circumstances, they may not qualify the city for an exemption. We specifically asked the DLCD this question. The DLCD basically solicited questions from cities about SB 1537, including the adjustment process. We pointedly asked that question and they didn't answer it. And I think they just don't know the answer to that at this point. So we're waiting for more guidance from them. But they did advise us that they will be providing more guidance later this fall. And they reiterated that they don't attempt, that we don't attempt to try to amend our code, because they will have the ability, if we apply for the exemption, to basically require a condition of approval. So if we need to modify our code, they'll have a condition of approval saying you need to add, X and X adjustments under a different process besides major variance. So we have opportunities to address that, and we shouldn't try to amend our code at this time. So this is my final slide. As Councilor Moop mentioned, we did take this to the council to get direction on whether or not they wanted us to apply the state land use adjustments directly, or whether they wanted us to apply for the exemption. No surprise, they did direct staff to go ahead and apply for the exemption to the state mandated housing adjustments. And this, we really didn't have anything to lose for this, because once we apply for the exemption, the state adjustments don't apply while that is being processed. So as long as we get it in by January 1st, 2025, we do not have to apply the state land use adjustments till we get a decision from DLCD. So that's great. If it is approved, we get to keep our current variance processes and criteria, which is great. But one of the things we do have to be careful for is that we could be required to amend our code as a condition of approval, which is fine. But more importantly, our exemption could be revisited or revoked if we get a lot of complaints to HAPO. So that's the one thing that is an unknown at this point, is if any complaints are going to be filed to HAPO, and could that result in us getting a revocation of any exemption we receive. But like I said, there's nothing to lose for us to go ahead and apply for that. So at this point, we're in a waiting pattern. We're just waiting for DLC to tell us what the application process is for this, because like I said, HAPO doesn't exist. DLCD is charged with being able to review these applications until HAPO is created. So once DLCD gives us that guidance, we'll go ahead and apply as soon as possible and submit that to DLCD before the January 1st deadline, so that we can avoid having to start approving those adjustments as of January 1st. So hopefully that all sunk in. I know there's a lot of details there, but I am more than happy to answer any questions that you have, either about HAPO, the land use adjustment, or any other component of SB 1537.
Does anyone have any questions, comments?
I guess I'll jump in and ask a question. Thanks, Jessica. Were in the list of allowed required adjustments in that table,
Yeah.
were there any of them stick out to us as could be problematic? Or are we applying for the exemption because it's just what we want to do, and we feel like, given our high, granting of a variance rate, we want to continue to own that process, and we think that qualifies?
Well, I mean, the big issue that we saw was what I outlined in the presentation, is that there are a number of these that are only allowed through a major variance. One example, which the counselor very briefly touched on, is in the Westlake Grove Design District. There is the only process for any variances in that district is a major variance. And I personally think that it would be great for them to have more flexibility, because that area of the city, in addition to having a lot of different design and site requirements, they're also dealing with very oddly shaped lots and other issues. I know that the Hacienda project had some issues with complying with some of the code standards, but there wasn't really any good relief valve because major variance was not a great option for them. So I think that there's a merit in having a variance process similar to design variances that we have in downtown or in Lake Grove to apply in Westlake Grove, but that's something we'll have to talk about later on. But our big concern is that while there is a variance process for every single adjustment in here, but there are quite a few that are only major variance, and that's the one that we're concerned about. So I think that's the biggest red flag for us. As far as individual variances, no, I mean, a lot of these fall under minor variance or other processes where it would just be like, okay, well, that's fine, that falls. But we're just concerned about the ones where it's only major variances. So, yeah.
Thank you.
Anyone else? No more questions. Thank you for your work on this, on the report. Do we have any other business to discuss? No, so on to schedule review.
Thank you, Chair Moreno. All right, this always takes a little while to get going here. All right, so before I go into schedule review, I suppose I do have an item of business after all. Just wanted to give you a reminder to try to respond to the quorum checks as quickly as you can. I think, yeah, we certainly, it would be better to know further in advance if possible. There are some ramifications if we do need to cancel the meeting if we don't have a quorum. So that is kind of the spirit that I'm making this request in. Really, it's just, if we do have to cancel the meeting, there are a number of things we have to do in terms of notifying TVC-TV, notifying various different folks that we sent out the meeting materials to in the first place, posting the notifications various places in physical form, and yeah, there's just a lot of sort of process involved. So the sooner we know, the better. So just sort of ping on that from our admin staff. But yeah, so just going into the schedule now, I think I mentioned at the last few meetings, our fall will be chock full of hearings. We'll have a hearing every meeting for the next 2 months, basically. So, we'll have findings after that as well. So it will be a full summer of hearings. Our next meeting will be on September 9th. It'll be on the housing production strategy. So those materials have been released publicly and provided to the required parties such as DLCD and Metro. We're also September 23rd on for a hearing for the stormwater code amendments that we've discussed here. Not too far from now, not too long ago. So Sonia will be leading that on September 23rd, that hearing. October 14th, there are some comprehensive plan amendments needed for the wastewater treatment plant update. So that's something that we're going to be helping out that project by conducting a hearing here at the Planning Commission for that component of that project. So that's something that's a bit new to the commission, but is pretty limited in scope in terms of what will come through the commission, but we'll be learning more about that on October 14th. And of course, citywide parking reform, and I guess we also refer to it as the Climate Friendly and Equitable Communities, or CFEC program. We will be holding a hearing on October 28th for that project here at the Planning Commission. So that will be the first hearing on the parking requirements in our code and comprehensive plan. So I won't go into too much detail other than that, but obviously we'll have findings for each of those hearings at the meeting sort of following after. So yeah, a lot of official commission business in the next couple of months. Thank you.
Thank you. Thank you for the report. And it was a full fall schedule. You said full summer
Did
schedule.
I say summer? Well, we didn't have as full of summer. I meant, yeah, chock full in the fall, September and October in particular.
Right. Thank you so much. Well, with that, this meeting is adjourned.